Judiciary Committee. We have pretty much the same folks with, so far, one exception here today on the committee. Welcome, Senator Steele. Do you want to introduce yourself to everyone? That's what Chairman Albert said earlier in his committee, so we'll take the time to do the same thing here. What mic number are you? Number 12. Tell us about yourself.
Thank you, Mr. Chairman.
Will you open us up in order of prayer, please, so we can get started?
I will.
All right, go ahead.
Sean Still from the 48th. Dear God, thank you for letting us all be here right now and keep us focused on doing the will of your word and your people. In your holy name we pray. Amen.
Thank you. Welcome to the committee. All right, the first thing on the agenda, do you have something you want to add? Mr. Full Leader, are you still Full Leader?
Yes, I am.
Okay, Mr. Full Leader.
Mr. Chairman, I feel like we're missing someone who the last 2 years was complaining about not being on this committee, and now he's not even here today.
In full disclosure, I was stalling for that very reason because I wanted to make a spectacle of that, and it fell apart, and so I just went to you, Sean. So maybe he'll join us eventually. We'll see. Yeah. So someone wanted to be on this committee so bad, and they begged for it for 2 years. Their politics just fell apart on them, and they finally get added back. They don't even show up. So when he comes in, we'll pause, and everyone will stand and clap. You'll know. Let's do that, okay? So we'll see if he shows up. All right. Let's get back to our business. We will start with the adoption of the committee rules. The committee rules are in your folder. They are, as far as I could tell, exactly the same as the last 4 years, I think, at least, that I've been doing this. Does anybody have any questions on the rules? If not, we'll take a motion to pass. We will take a motion to pass. So moved from Dr. Watson, a second from Senator Jones. All those in favor of the motion, please say aye. Aye. It is unanimous. We have rules. All right. He's not going to walk in now. So we will go to the agenda. Senate Bill 9. Chairman Albers, come on up. Welcome back.
Mr. Chairman, always an honor to be in front of your august committee to present important legislation. Thank you for your leadership and all the people that serve. Very quick background.
We're working off LC 560249, is that right?
That is the correct bill number, yes.
All right,
Thank
go
you
ahead.
so much. That's Senate Bill 9, which is the Ensuring Accountability for Illegal AI Activities. Very quick background. We had a study committee this last year on artificial intelligence, met with all sorts of industry experts throughout the state. I'm also part of a multi-state policy group of our fellow legislators who are working to bring some consistency, transparency, and effort together so we don't have a patchwork of 50 different laws throughout our country. In hoping that one day we might have some type of some federal solutions, this is an attempt for us to work together to lay some foundational items in place for artificial intelligence. So we've been working closely with our folks in the House who had a subcommittee related to the same thing. So what this bill does is it is intended to ensure that artificial intelligence, which is such a powerful tool, perhaps I believe one of the biggest things will happen in our lifetime, does not get abused to allow for illegal activities. And knowing that this is so powerful, we need to make sure we have defined it in the code, which we have done, as connected it to certain
If you'll pause for a second.
Yes.
Ladies and gentlemen, please help me welcome, returning to the Judiciary Committee, Chairman Blake Tillery. Welcome back, Chairman Tillery. What mic are you?
So sorry I was late. I got lost on the way. It has been a while.
Yeah, you're out of breath. Before we get back to serious business, we wanted to celebrate your return to this committee and you doing whatever deal you had to do to get back on the committee. And so James Beal gave this to me, so everyone knows it was James. Where's James? He in the room? Well, it's James. Right here. You know I was going to call you out. This was his idea to give this to you. I want to present you with the, how do I say it? Milter Award, which means Man I Love Tort Reform, and it's a pin you can wear. And you can wear in this committee, so I'll bring this to you. Would you like to wear this in the committee?
Thank you. I will if you want me to.
All right. Thank you. All right. No more jokes. Back to business. The floor is yours.
I don't know how to follow that, Mr. Chairman.
I don't
I'll
either.
do my best. All right, so this bill includes definitions for the standard of obscenity, and provides for some additional sentencing to those who commit a crime. Very simply put, what we could not do just 2 years ago is mainstream today. By using tools that are either free or a nominal amount of money, we have seen exploitation happen and fraud at a degree that candidly, again, we couldn't even foresee just a few years ago. We've seen it in the news where you've seen young girls, particularly teenage girls, where somebody has used artificial intelligence to use her face and then superimpose sexually explicit photos of that person that, while not real, they look about as real as could be. We're also seeing fraud being taken at a level never assumed before, and this bill seeks to address that. So very quickly, again, this bill is named the Ensuring Accountability for Legal AI Activities, and then it repeals the current 161280 and amends it to do several things. First off, it defines the term throughout this bill of what artificial intelligence is. Important to note, we work with all sorts of experts here in the state, as well as colleagues in the House, to define artificial intelligence. We've been working very closely with all those who have a stake to make sure that they've been well heard and represented. It states any person who commits a crime of distribution when they knowingly distribute, solicit, or possess with the intent to distribute depicts a child that is obscene and was created using artificial intelligence, outlines how long the person who commits a crime should be imprisoned, not less than 1 year, but no more than 15. And it's not required that the child depicted actually exists as well. So if you can imagine, they're taking multiple images and creating new images that is not actually a human being that we would see, but it still looks very real. Defines obscene materials, goes through, I'm not going to read every part of the bill, but it goes through in section 3.1 and talks about all the different subsections it applies to. And while they're not listed, and not all of you probably have the code book in front of you, if you begin where it's got 16.590 and you keep going down, I'm just going to read those to you what they are, that artificial intelligence applies to these designated offenses. So it goes in order: stalking, aggravated stalking, exploitation of a disabled adult, elder person, or resident, enticing a child for indecent purposes, publication or other dissemination of the identity of a female raped or assaulted with intent to commit rape, any misdemeanor or felony involving theft, any misdemeanor or felony involving criminal reproduction or sale of recorded materials, any misdemeanor or felony offense involving mortgage fraud, misdemeanor or felony with forgery and fraudulent practices, misdemeanor or felony offense against public administration, misdemeanor or felony against public order and safety, misdemeanor or felony against public health and morals, and finally, fraudulent election interference. When you skip down then, we've got areas where we enhance sentences specifically, and I will just outline a couple of those. If they found as a misdemeanor, impose a sentence of confinement of a period of no less than 6 months and no more than 12 months with a fine not to exceed $5,000. And then for a felony, impose a sentence of no less than 2 years and a fine not more than $5,000. In working, I recently got some information from our friends, the Prosecuting Attorneys Council. I want to thank them for coming forward. We did find an area in there that was found to be unconstitutional on lines 72 and 73 that we will need to strike. So the bill stays consistent. My apologies that we got that at a late hour for you, Mr. Chairman and committee members. As well as on line 111, we realized inadvertently we just have to add a few words, because if you begin on line 111, it says, if the designated offense of which the defendant was convicted is a felony, we need to say, and does not already have a mandatory minimum. Otherwise, we could actually inadvertently lower the mandatory minimum. We don't want to.
Which line were you on?
That would be line 111. When you get to the word felony toward the end of the sentence, and does not have a mandatory minimum currently, then we would impose a sentence of imprisonment for a period of not less than 2 years and a fine of not less than $5,000 on the following two lines. Again, that would, otherwise we would actually bring something down by accident. That's the entirety of the bill. Again, we've worked with all, I believe, the critical stakeholders. I know some are signed up to speak today. Did have the group RAIN, which helps with women and child sex abusers who could not make it to the committee meeting today, but they wanted to express their support, and they will come down to future meetings, both in the Senate and the House, to support the work that we're doing. And with that, Mr. Chairman, I'd yield for any questions.
You may want to defer this to another speaker because it's a little bit in the weeds. But looking at the trial, I guess it's like a bifurcation of trial where you would have the case finishes, looking at lines 87 through 93. So first, a jury would determine someone's guilt. And then is it envisioned that same jury would then go to a separate trial to deal with the evidence of whether the defendant knowingly and intentionally used the artificial intelligence system in the commission of the offense? Is that how it's envisioned? Is the same jury goes twice? Or is it another whole trial that has to be reset?
My understanding, it would be together. And I can't say the words up there because I don't have enough money in my pocket. But I don't have a law
What
degree.
words?
I don't
Okay.
have a law degree.
That counts, by the way.
Thanks.
So, you're not a lawyer, but is what you're trying to say.
What's the going rate now, Mr. Chairman? Is it
Well,
five?
somebody put $5 in last time. We'll take 10.
Okay, perfect, great.
So we can defer. Is there someone else you want to turn to that can answer that, or maybe they're already speaking? I just want to see what the intent is the setup
Why
of
not
this.
bring up my friends in PAC? Would
Okay.
that be okay?
Come on up, Robert.
They are lawyers, so I was wondering if I get a discount.
Okay.
Great.
Because my fear, Robert, is the question I have is, are we going to have to go reset and get another jury picked? What's the intent?
I'm Robert Smith. I'm with the Prosecuting Attorneys Council. Happy New Year. My reading of this, and I believe talking with the senator, I believe that the intent is that it's going to be the same jury. It's not going to be a case where you have to bring in a second jury, because reading along it says the trial shall immediately be recommenced. So to me, that suggests that it would be the same jury again.
So is there other places you're aware of in the criminal aspect of trials where you have a situation like this where you have a second trial?
The first one that leaps to mind is convicted felons in possession of firearms. By law, and also for fairness aspect, we try someone as to whether or not they're in possession of a firearm. But the jury has no idea whether or not they're a convicted felon. If the jury finds that the person was in possession of a firearm, and by law they were supposed to have been disarmed, then we have a second trial, or a continuation of the trial with the same jurors to prove whether or not the person had been a convicted felon at the time they were in possession of the firearm.
Is that the only place you're aware of where we do this way?
That's the first one that jumps to mind. There may be others, but that's kind of the easiest analog I could think of.
Why do we want to have these decided separately? Not your idea. That's
No, sir.
fair. Do you have a reason
You know, when we gathered all the folks together, we started this last year. We pulled all the experts in. This was the language we crafted together. But, Mr. Chairman, I would certainly defer to your wisdom and judgment.
Who are the expert? Who is it that wrote the bill initially or gave the idea of the bill?
Gosh, we probably had 25 people working. We had a large crowd of folks together and throwing stuff out there. And I think, I can't remember who the legislative council that ended up scribing it, but we pulled in data from many other areas in other states.
If I may, one of the things, because you're enhancing the sentence, you have to prove it beyond a reasonable doubt.
Yeah, the enhancement part itself, yeah.
Yes, sir.
And the line you mentioned, 72 and 73, would that be striking that entire section? Is that coming from you, Mr. Smith?
Yes, sir. That was held to be that prime was held to be unconstitutional, a violation of the at least the First Amendment by the Georgia Supreme Court several years ago. It's still a crime on the books, but it's unconstitutional. We can't attempt to use it.
Do you know the case site by chance?
Supreme Court, Dye versus Wallace, 274, GA 257 in 2001.
Okay. There are other questions from the committee. Senator Parent?
Thank you, Mr. Chairman. Thank you both so much. A question that was raised to me is a concern that there was no sort of like Romeo and Juliet opt-out provision within this, the way we have in some other parts of the criminal code. teenagers were swapping photos back and forth, and it would, I believe, if it were AI generated, it would not be exempt the way some of those other activities might be. Could you please speak to that?
Yeah, Senator Estevez brought that to my attention prior to the meeting, and I have to think through that one. I think my concern is, I support the Romeo and Juliet laws that we have in several different areas, especially when someone, took a photo and sent it to somebody, et cetera. But if I was going to use an artificial intelligence tool to specifically do this, I'm talking, that's some serious thought process to go ahead and now make sexually explicit content with a tool in order to then send it back out. So I actually see these as being a little bit different. I'm not sure we should exempt someone just because they were 15 and 17 or 14 and 16, as opposed to, well, someone took a picture and they sent it over of themselves or the other person willingly. I think this is a little bit different scenario.
Okay, thank you.
Other questions for the author or Mr. Smith at this time? All right. Leader Hatchett.
I have a question about some of these offenses. Last year we passed a bill that essentially said it can't be a defense to any of these crimes to say that the AI pornography or something was generated using AI. And so right now I think a prosecutor can prosecute them for these crimes and they can't use that as a defense. With the rule of lenity and competing sentencing, is this going to create any loopholes where someone could essentially charge someone with, indecent exposure of a child, or charge someone with a felony, and then the judge would have to go, well, this is actually AI generated, and so it's a completely separate charge, when they could have charged them with a harsher penalty to begin with?
I don't think so. And the reason why is that the 161280 is about the distribution of obscenity or obscene materials that's AI generated. What you're referencing would be a possession of child pornography or revenge porn or something like that. And that provision that says the defendant can't use AI generated as a defense is a separate crime with separate elements, so that you would be separate and we wouldn't have the rule of lenity to touch the sentencing issues.
Okay, thank you.
Mr. Smith, were you wanting to have more testimony on the bill?
No, sir, I'm here solely to answer questions.
So PAC has a neutral position on the bill.
Yes, sir.
Is there a reason y'all aren't for or against it? Or
I'm just here to answer questions.
okay.
To be honest with you, we haven't asked the council, and neither one of the associations has weighed in.
Well, that's why I'm asking. So it's not something that's coming from PAC, but you don't have any opposition to it?
No, sir.
Okay. All right, those are all the questions in the committee. This time we'll go on to our speakers. Next, we have Mike Griffin with Georgia Baptist Association. Good afternoon.
Thank you, Mr. Chairman, for this opportunity to be here today and to support Senator Albers. We really appreciate what he's doing here in this committee. I am Mike Griffin. I'm with the Georgia Baptist Mission Board. I'm the Public Affairs Representative. And one of the three areas that I represent for Georgia Baptists, who represent up to 1.4 million Georgians and 3,500 churches, is child sex abuse prevention. That's what we work at. I did about 6 conferences. Well, I did 6 conferences last year around our state dealing with this issue. So we think it's very important that we have legislation like this. In 2017, we passed a resolution as a Georgia Baptist Convention entitled Moral and Social Public Health Crisis Created by Pornography. And one of the major areas that we're concerned about here that we think this bill will help with has to do with the encouraging of sexual predators out there, and that pornography ends up being gasoline on the fire that we already have problems with. The porn industry can normalize violence and abuse of children. So we do support that legislation from a predator perspective, but also we're also concerned about it enhances child access to porn as well. While this may or may not be targeted as such, sometimes it can be. because I have seen already there has been data that shows that children being exposed to pornography at anywhere from 9 to 10 years of age. And I've also heard that a majority of those may not even be looking for it. It may be looking for them. And so we really do think that it's important. We are living in a day since 2022. For the first time, there was more peer-to-peer abuse, 52% in 2022, than adult-to-child abuse. So it's really getting worse among our young people now because of their easy access. I've said, what would take me 3 months to find on the side of the road, I might be able to find in 3 clicks. So it's very concerning that we do everything. We think it's very important that we do what you're looking at doing here, and that is we limit this absolutely as much as possible. So we appreciate the senator for introducing this, and we support him wholeheartedly, and we'd encourage the committee to support it as well and vote for it. Thank you, Mr. Chairman.
All right, thank you, Mr. Griffin. Any questions from the committee? All right, thank you.
Thank you.
Next, we have Mason Rainey with the Technology Association of Georgia. Good afternoon.
Good afternoon. Thank you, Mr. Chairman and members of the committee. I'm Mason Rainey with the Technology Association of Georgia, or TAG. TAG is a membership trade association representing a little over 1,200 technology and tech-enabled companies throughout the state of Georgia. We just wanted to quickly say that we are supportive of this important measure and to thank Chairman Albers for bringing this forward and all of his work on it, as well as the tireless efforts of the AI Study Committee over this past summer. Thank you.
All right, any questions, Mr. Rainey? Thank you. That was everyone that signed up to speak for the bill. Now, in opposition to the bill, start with Thomas Weaver, private citizen, but no stranger to this committee.
Well, thank you, Mr. Chairman. To the audience, I had to sign up in opposition to the bill not to be a jerk. I have a tremendous amount of respect for your friend and colleague, Senator Albers, and what he's trying to accomplish is very, very important. I, too, recognize the profound implications of artificial intelligence, and arguably, it could be a force for good. It could propel our state to new economic heights and thrust humanity to new frontiers in medicine and science. Or, in the hands of a bad actor, it could be used to undermine the very weft and weave of our societal framework and cause our civilization to unravel at the seams. Indeed, it has been warned by many scientists and also authors and fiction writers from the 1970s and 80s that it very well could be the very last thing that we as humanity ever make, because it could potentially turn sentient and reach singularity, which would be very bad for all of us, and God would have to personally intervene. But I don't want to go down that rabbit hole here. If it were up to me, artificial intelligence wouldn't be in the hands of anybody. It's just that dangerous. To the extent that this legislative measure doesn't seek to create a new crime of just flatly prohibiting artificial intelligence, I wish to share just one or two small concerns that have been touched on by our friend, Senator Albers, who's also a member of my legislative delegation. The rule of lenity issue had been discussed, but I'd like to address another issue that I saw with the rule of lenity, if it should meet with the chair's approval and with the approval of the committee. Starting on line 111 through 113, the measure would require the trier of fact at the trial court level to impose a mandatory minimum 2-year sentence in the Georgia Department of Corrections if a criminal defendant is lawfully arrested for, duly charged with, and properly convicted of the underlying felony, if it is determined through that hearing, that second-tier hearing and the sentencing phase of the trial, that the defendant utilized that artificial intelligence. However, the way that the bill is drafted under Section 2 of the bill, which creates that new offense, on line 38, that defendant is entitled to potentially be sentenced to as few as 1 year, so a year and a day, to get out of that misdemeanor range. That's not to suggest that any of our seated Superior Court judges would impose a 1-year sentence, but I just imagine a hypothetical scenario where a criminal Superior Court judge in a criminal proceeding might want to impose a 1-year sentence. Not saying any of them would. I probably could count on fewer than one hand any that would want to do that, but let's say, just for the sake of hypothetical, what if they wanted to and they can't because they have to impose 2? would that defendant through skilled counsel be able then to file for a writ of certiorari before the appellate courts above and ask them to remand with instruction or vacate, because the legislature said that they only have to be sentenced to a mandatory 1 on the very low end of the sentencing scale. I don't know if that's how it would work on the ground, but because this is such a new frontier of law and how this would have to be utilized in the courtroom anyway, because artificial intelligence, I remember most of us were in the room when a representative sat here, I think it was Representative Brad Thomas, and he put the Senator the Colton Moore video, and you could see how it's progressing, and that was a year ago. It says that the computer chip doubles in its computing power once every 18 months, right? So it gets better every 18 months in sequence. So odds are that it has twice the ability as what it did almost a year ago. And almost a year ago, even I admit that you couldn't tell the difference, at least from a standard casual observer, of whether or not that was a real person or not, or whether that was the person's real voice or not. When perceived through the ears and eyes, you just don't know. And I can imagine in the courtroom, whether it's this or any of a plethora of other proceeding, whether criminal, civil, or otherwise, I just don't know how attorneys would be able to unravel that of, no, this is real, this is AI, no, this is AI, this is real. I can just think that's going to cause all kind of problems. I have no clue how the judicature is going to handle that through their uniform rules. Saying that also, I do want to mention, although, again, because it's AI and it's brand new to the code and there's no corresponding code sections that we can really align it to, because no other crime in the official code of Georgia annotated throughout Title 16 or any other title has artificial intelligence as a element of an offense. So there's really nothing to compare and contrast it to. But is it possible, considering the Romeo and Juliet provisions that Senator Perrin alluded to, or in other places of the code, is it possible that this legislature is on the precipice of creating, as I explained in my letter, a law that would protect artificial digital children and impose a criminal sanction more severe than the protections that a real living, breathing human child would receive in a very isolated fact pattern or scenario? I'm not saying it would happen, but is it possible? And because of the artificial intelligence component, I can't sit here and point to a case or a statute like I normally would, as I've done over the years. This is not to pick apart your friend's bill. I fully support it. It's just I had to sign up in opposition based on the very specifics of the rule of lenity issue. Thank you for allowing me to speak, Mr.
All right.
Chairman.
Questions for Mr. Weaver from the committee? All right, thank you. Next, we have Maisie Lynn Girton. I think is Mr. Brown coming with you from Georgia Association of Criminal Defense Lawyers.
Thanks for having us. This is Ryan Brown. He practices out in the Noonan area. You all might be familiar with the fact that we've begun bringing Defense Lawyers of the Week with us. They take a leave of absence from their practice, from client meetings and all the things, so that you guys can have some real-life courtroom expertise. I've been out of the courtroom for over 10 years now, so I need people like Ryan to help me too. We too have a concern about the Romeo and Juliet potential here for a conflict. I mean, I don't want to belabor that point. You've heard it a couple of times, but if you had any particular questions about it, I'd be glad to address them. But we are concerned that this would have the effect of what Mr. Weaver was saying, punishing someone who actually harms a child to create the images more harshly than the person who, the other way around, punishes the person who does not use a real, sorry, my brain.
Can I jump in? Maybe it'll help too.
Yes.
So in the Romeo and Juliet law, though,
You get a misdemeanor in that context.
Are you talking about Section 2 of the bill, not Section 3?
Section 2, right. So Section 2 of the bill.
And what is, when we talk about Romeo and Juliet, tell us, the committee, what that means. What is the defense?
So if a child is depicted in an image and that child is at least 14 years of age, and that image is possessed by a child who is under 18, that's a misdemeanor violation of 16-12-100.
Is that just to possess the image?
No, you can
I believe it's with intent as well.
go ahead.
It's my first time, so y'all be nice to me.
Fire away.
I can't quote 16, 12, 100, or in any of the other ones, certainly not as good as Mr. Smith would be able to. But I do believe that it would include possession with the intent, et cetera. And we've got another point on that later, but.
So that was my question. This code section as it's proposed, you would distribute, solicit, or possess with intent to distribute the image. And so if someone has an image of a actual child, would the Romeo, and they're at the age where that defense would come in, they would get immunity even if they had the intent to distribute that image if they were a certain age?
I want to look that up before I answer incorrectly because I'm not positive. I know they may get the benefit of the misdemeanor treatment, and we'll look that up. I know they won't get immunity from the prosecution.
Because I was trying to see if it really is the same crime or not. Because this crime talks about distributing with the intent to distribute. It's a little bit different in my mind than boyfriend, girlfriend. One happens to be over a certain age. We treat that different under the law. Mr. Walker, you want to weigh? I guess I should turn to you every now and then, shouldn't I? Mike 1? Whenever you're ready. I'm ready. You got to just yell. Don't text me. Yell at me.
This is not directly on what was the previous discussion, Chairman, but it does appear that Section 3 it looks like it may be modeled on the hate crime sentencing enhancement framework. So that kind of addresses an earlier question as to, and it may also address the lenity issue because if it's being enhanced, if a judge were to impose a sentence of 1 year, then the enhancement would require a 2 year, so that and you could go up to 15. So perhaps there wouldn't be an enhancement if a trial court imposed a 15-year sentence, but it does seem to be modeled on that framework.
Do you think the language saying shall immediately be recommenced would cover us, that it would be the same jury?
Yeah, that language is not identical to what's in the hate crime, but it does seem. I think Mr. Smith's interpretation of that is pretty reasonable.
Okay.
It suggests that it would be the same jury.
Do you have an answer on my Romeo and Juliet scenario?
I'll catch up with you, and then I'll let you on the next one.
Chairman, it does look like the possession with intent, which is in 16-1200 B5, would get the benefits of the misdemeanor sentencing under the Romeo and Juliet provisions.
So is it true under this scenario, if it's an AI image, you don't get the Romeo and Juliet treatment, as you said, but you would if it was an actual image?
Yeah, so 16-year-old makes an AI picture and sends it to his high school buddy in the football locker room. He's going to be prosecuted for a felony and not a misdemeanor. If it's a 16-year-old creating it, having ChatGPT create an image of a 16-year-old explicit image, or an explicit image of a 16-year-old, he shows that to his buddy in the locker room or sends it to somebody on the bus, that would subject that 16-year-old to felony prosecution as opposed to misdemeanor.
Okay.
Even if it did not include, we talked earlier about you use the face of a real child or something like that. This could be even if the image was completely created by artificial intelligence.
Okay. I'll let y'all continue unless somebody else has a question right now on that topic.
The procedural conversation you all were having as well, one of the questions we have, and it's just a question, is whether or not there would be another round of opening statements for this second sentencing hearing. It's just not addressed. The procedure of how to handle this type of recommenced evidentiary proceeding it's not laid out.
Wouldn't that normally be in Superior Court rules, though? Because we don't say that in code already, do we, as far as opening statement and the process of the trial?
Possibly. The other concern that was raised about the distinguishing this from other bifurcated trials in the code is this is mandatory. Bifurcation in, for instance, possession of a firearm by a convicted felon, or even under our gang statute, is something that the defense requests because we're concerned about prejudice. It's not something that, in this bill, is forced on the court.
But wouldn't that be a benefit for the defense in most cases,
to have it separate? It is, for sure. But in this case, the judge is given no discretion at all. It's simply that if the state alleges this is true, then upon conviction of the underlying offense, the trial court shall immediately recommence the evidentiary hearings on the issue of sentencing. it doesn't give, there's a possibility here of giving the judge a gatekeeping function so that you avoid this extended, now protracted sentencing situation, because the state does have to lay out specific factor or factors that authorize the enhancement. But if the court gets a notice that they don't believe satisfies that, building in an opportunity to cut that short, because Mr. Brown was explaining to me that in his practice he would expect this to, like, if a trial on one of these charges would take him typically 5 days, this could be a 7-day trial. And you could imagine that if it's a longer trial, it could be even longer depending on what the sentencing hearing would need to be. And that's in the private context. In the we often hear in these rooms how 80 to 85% of the cases are handled by the public defender's office. So now you've got those resources being used longer on trial. Not to mention the fact that in any case when the state files this notice, there's now necessarily going to need to be expert testimony available on the issue of AI.
I think, Chairman Tillage, is it this topic you wanted to ask about? Did you have your button pushed? Go ahead.
Thank you, Mr. Chairman. Macy, my question is, and Counsel, is it Rob?
Ryan Brown,
Ryan,
but
sorry.
I'll answer to anything.
The question I have on this is, I understand the separating and trying this later. Could you not just create this as an element of the crime and that be a lot simpler?
Well, I would imagine, I won't speak for legislative counsel, but I would imagine they didn't want to do that because to go into all of these articles and modify all of maybe there's a way to do it.
Wouldn't you just strike the line 87, strike in B, strike the first sentence? Because then B would start if the trial fact finds the defendant guilty of such designated offenses. Well, I'd want to strike more than that, wouldn't I? You'd want to strike the second sentence, actually, and then just use that as a beyond the reasonable doubt standard as an element. Okay.
That does seem like a potential way to streamline it, to not have to have a second.
I guess my question is, there's no doubt that at least the men and women on this podium, and I think most in the audience, want to ban this. We do not want that to occur. We'd like to do it in the most judicially efficient way possible.
Right.
If that means we could just strike the sentences either 87 and 88 or 88 and 89, could y'all help us with some language that would do that?
Cut that whole section.
I thought about cutting the whole section, but I'm afraid if you do that, and I heard Senator Parent say that, my concern is you might actually cut the element itself, cut it out as an element. That would have been my first thing, is just to cut B.
Are you suggesting there would still need to be notice given, but just that the determination of whether AI was used?
I think Mr. Walker may want to weigh in. Is this on this topic? Okay, let's let him weigh in on that.
If it would be helpful, I could read the provision from the hate crime enhancement. It does seem like it could be lifted and applied here pretty neatly.
Okay.
So the hate crime language reads, subject to the notice requirement provided elsewhere and in enhancement of the penalty imposed, if the trier of fact determines beyond a reasonable doubt that the defendant intentionally fill in, then the imposing sentence shall. Mm-hmm. So that would be the framework that I think could be lifted. I'd be happy to draft that out and apply it to this language if that's your pleasure.
Will there be any opposition from your standpoint to having the one trial? Is that part of basically what the jury is charged on?
Well, I think that would it would put us in a similar posture and you could chime in too if you think. I think it would put us in a similar posture to where we are with these other crimes where there is other prejudicial information that could come in, like the firearm case or the gang case, that we could request a hearing, we could request bifurcation.
Basically, you could file your own motion, have a standard for it. You could have it bifurcated.
Sorry, I didn't mean to interrupt.
No, good, please.
Yeah, I was just say that, in any of the other cases where it's not required for bifurcation, if I find as defense counsel for someone a reason for it, I can always ask the court to bifurcate. There's nothing that stops me.
Is that a code section that applies to any crime?
I don't even know if it's a code section. I think it's just motion to bifurcate. Right?
Okay.
Yeah, and if the judge wants to do it, he can or not. And that would help us just, I run a small practice, so I'm a business owner first and then a lawyer second, and we start talking about spending extra days in court for something that has to be bifurcated, that maybe we could have tried without it being bifurcated, is
Right.
a stressor on us as small business folks.
Right, and also public defenders as well, of course.
Yeah, a couple extra days in court and those kind of things.
Senator Cowser on the same topic has a question.
Yeah, so I'm stuck right here along Senator Tillery. I'm on lines 105 to 107. On the enhancement, I'm just wondering from your perspective, how difficult would it be for the prosecutor to prove that the defendant knowingly and intentionally utilized artificial intelligence? And how do you prove they used artificial intelligence? That sounds like we're now calling and putting the burden on the state to come in with a computer expert or somebody to prove that that's where it came from, rather than, you know, photoshopping a photo that's not AI, but it's using a computer. I don't know how difficult or complicated Chairman Albers understands AI better than the rest of us, but do you have thoughts on that?
Senator, if I may, I'm happy to respond to that. I do think that, you know, if the state chooses to allege the artificial intelligence, it will 100% be their responsibility to prove it beyond a reasonable doubt, and I think it would. I'm not the expert on speaking to how much that would cost them. I'm sure that they would require. I'm sure there would be Daubert challenges first, and then some form of expense to them, whether it's through the GBI or local law enforcement agencies that have to hire experts locally, or whether they contract it out to come testify to these matters. And I think the same would be on the defense, where we're looking at a period where we've got to hire experts as well, which I think is what kind of adds to the delay. But, you know, I can't speak for the prosecutors or the district attorneys about how they would go about it, but I do think there's got to be somebody. I think it would have to be an expert, at least at this point. Maybe in 50 years it's not, but I think at this stage it would require expert testimony from them. I hope that answers the question.
Sorry, and the definition of the use is found at lines 85 and 86, and it means to be the proximate cause of an artificial intelligence system receiving an input or providing an output. And, you know, I've been to some judicial council meetings over the last couple of years where AI has been discussed, and what is said in those spaces is, if you're researching a legal case using Lexis, if you research a legal case using Westlaw, if you Google, you're likely using AI. I mean, there are AI underpinnings on most of what we use when we pick up our phones. And the definition of receiving an input or providing an output, it doesn't seem like it should be difficult to me. I mean, we don't know, right? We haven't lined it up, but it's a pretty broad definition that's not very precise.
Okay. I mean, we're all plowing through together. I know it's an incredibly powerful tool and dangerous tool that, you know, Chairman Albers is on to something here that we better rein it in or put these guardrails around it. But the devil's in the details.
It is.
Yeah.
Yeah.
And I can't be as enthusiastic as Mr. Weaver, but being set up to choose whether we support or oppose a bill, we definitely oppose it as drafted. We don't oppose the policy. We understand what the goal is here. And we're not here to try to allow or encourage children to be harmed. You know, I hope that you would never perceive that about our organization. We just want the law that's going to be enacted to be as, you know, efficient and reasonable as possible, of course.
Do you want to continue on with outlining your concerns? We stopped you at the first one.
Thanks. Well, no, I think we've mostly gotten them in. Let's see,
Okay.
just by going here and there. Yeah, that covers it for us, based on everything else that's been said today.
All right, any other questions for Mr. Brown or Ms. Girton? All right, thank you. Chairman Albers, you want to come back up?
Thank you.
I'll let you close out. It seems like we probably do need to work a little bit more on it. Welcome back to Judy, huh?
Always a pleasure.
Do you have anything else you want to add?
Certainly. First off, I want to thank always great work from this committee. You know, as we go through these processes, I think that, you know, Chairman Cowser said it best, but we're all figuring out as it goes. This is literally changing every single day. And some of the models that are out there are 100% smarter every single day. We are at what's called level 2 of AI now, which means it's smarter than every human on the planet. It took us almost 5 years to get to level 1. It took us 5 months to get to level 2. That's how fast we're going. So I think that, you know, what Legislative Council brought up, what Chairman Tillery brought up, makes perfect sense. I want to address Chairman Cowser, you said about having an expert. That's a really good point. And it's really no different than we'd have a forensic computer analyst do today when someone does anything either online or on their local computer. They would go in there and they would do the typical assessment. When you do things, though, that are cloud-based, you know, like anything else, if you get a warrant to work with those providers, then they can more easily tell who's accessed their systems, and they trace things down. I'll make your eyes roll in the back of your head by getting too nerdy on you. But the more it's actually in the cloud, sometimes the easier it is for us to connect those dots. Again, they will all change over time, though. So, Mr. Chairman, I would turn it back over to you, and obviously the other two sections I mentioned that our friends at PAC brought up that would need to be adjusted as well.
You have another question? Who's mic 4? Is Senator Rett?
Thank you, Mr. Chairman. I support you on this bill 100%. My only concern is, you know, being a coach, being a teacher, and being a first sergeant Air Force, young kids do some dumb things. And I just wouldn't want to see a young kid do something dumb and get kind of, have his life ruined. You know, I remember having to go through the barracks and kids have different pinups and this and that, you know. But whatever you come together with on this bill, you have my support. But I just wanted to inject that thought.
Thank you. Now, Senator, you bring up a great point. As always, I think we give pretty wide latitude for our prosecutors and our judges based on the specific circumstance, and certainly with children, to make decisions on how they want to charge and or sentence people to do that. And I think we in Georgia do a good job on that. The goal right here, I think, is just really to make sure that, you know, I would take this, here would be my analogy. We've been riding around in a horse and buggy, and we skipped going to a motorbike, a car, electric car, et cetera, and we went right to a rocket ship that can go to Mars. That's just how much faster we advance to get there, and this is a tool like we never imagined, and that's why it's so important.
So I'll echo what Senator Rett was saying. I support your bill, support obviously what you're trying to do. I think it'd be great to get a substitute together with those amendments you already have to do anyway. But also, from my perspective, I'd like to look at the Romeo and Juliet statute and whether it is truly consistent, and whether we need to have that defense available in the same way or not. I don't know the answer without looking at the code section. And also, you may want to get with Mr. Walker on the hate crimes language, if that helps cleaning up in Section 3, and maybe consider whether it needs to be mandatory bifurcation, or if existing law already kind of covers the ability of someone, as I think Mr. Brown was saying, to petition for that in certain cases. Those are my notes. Let's see if anybody else in the committee has anything else they want to add. All right.
We'll work on it and get it back to you, Mr. Chairman. Thank you for
Thank
your
you.
support.
Appreciate you. Thank you. All right, with that, we'll go to the next and final bill on the agenda. Senator Ginn, who stepped out in the hall. Somebody wants to grab him, please. Come on up. See how easy it is?
Yeah, I like that. What did they I really like it. One of the things that I want to...
Well, hold on one second. Slow down just a little bit.
I first want to make sure that your esteemed committee members
Thank you. Thank you,
are up
Senator.
here where we know who they are. And just because I saw the dollar, I'm not a lawyer, and you took the top off while I was
Yeah, it's
so
'cause-
put a little money in there.
All right. Chairman Albers owes us 10, so.
Mr. Chairman, would it be okay if I ask
Yeah, go ahead and have a seat.
my esteemed friend Rushi Patel to sit with me?
He might not want to.
He might not. That's true.
So we're
It's a
working.
little warmer in here in Judiciary, I understand.
We're working off, with Senate Bill 12, working off a substitute which is LC 473296S. Is that right? All right, Senator, again, the floor, and Mr. Patel, the floor is yours.
Thank you very much, Mr. Chairman. This past August, and I guess the best advice I ever had from an attorney was my county attorney, where I'd been county manager. He said, Frank, do whatever you can to keep the judges happy. Very smart guy, said they paid a lot of dividends as a county manager. Said they never want to tell a judge, said anything except yes, sir. So for me, when I look at what the Supreme Court ruling was in a case involving a contractor working for Georgia Tech, I think they made the right ruling. I just think that we left a blank in the law, and I looked at what happened, and basically they're saying that if somebody has an open records request that should go to an agency, which I would think would be a public entity, the city, county, state, agency, whatever the case may be, that we want to make sure that it does go to the public agency and not to a private enterprise. And so, quite honestly, when I saw that case, my background in local governments, I've managed 2 cities, a county, 2 development authorities. I've chaired economic development and tourism. I understand business community and business interest here in the state, and I want to make sure that, hey, we didn't get to be number 1. Well, actually, we got to be number 1 when I chaired economic development and tourism. So they renamed it, added the tourism side. But we've been doing that for about 11 years now. And to me, I want to make sure we stay number 1. So I spoke with the governor about the situation, and he suggested that I work on some legislation to fix it. So that being the case, I talked to some of our excellent attorneys in the Legislative Council, and I actually spoke with the governor's former counsel, and he said, hey, the simpler you can make it, the better off we're going to be. Now, for me, one of the things that I want to make sure that we do is that I'm a big proponent for government and sunshine. Anything that's out there that hey, government's doing something, we're all taxpayers, we're paying to all these different agencies, that you ought to be able to have access to those. I just want to make sure that the record request goes to the agency of which we're paying those taxes to, not to a private enterprise. And so when we look at what's going on with the private enterprise, I could see, and what my discussions were, you'd have somebody want to start up a business. Guess what? We're just going to barrage them, because anybody could make an open records request. It's not relegated to any particular person or agency, any news media outlet. It can be any citizen can make an open records request. So if I happen to be the competition for that private company, and I wanted to cover them up with open records requests, I could do so, and probably tie up a lot of their resources and time, and if I worked hard enough, I could probably get them out of business. So for me, that's not one of the things that I want to see happen. I want to make sure that we make the open records request to the public agency that is responsible for those records, and that they can't go hide them. I don't want a public agency to say, okay, we're going to dump our records over here with file company or whatever, and it's spelled out in the bill, that just because they've given them to a contractor or somebody that's working for them, they're still public records. So I'll ask Mr. Patel to add to that.
Yeah, thank you. And I don't know if that's, there we go. Good morning or good afternoon. I don't know what time it is. Senator Ginn is correct, is that we at GMA also are big proponents of transparency. I've been teaching open meetings and open records classes for 15 years now. And I think he's hit the nail on the head here, is that we've always viewed that the records request needs to come to the government for the very specific reason of our government officials get training on this. Private businesses don't. And if the records requests go to private businesses, there's going to be problems. But I think you can go back and look at the genesis of the Open Records Act and see that there is a conundrum here. And I agree with him. I think the Supreme Court got the decision right based on the definition of public record. but I apologize for this. Senators Calzert and Parent and I think Senator Watson were the only ones in the legislature the last time we did a major overhaul of the Open Records Act. But the issue is that when we did that last overhaul, I think it was pretty clear through the language that the intent was for these records requests to come to agencies. And you can tell that by sections that aren't included in this bill. If you look at 50-1873, if you look at 50-1871 in particular, 50-1871 in particular talks about the process of filing an open records request. In the process of filing an open records request, it talks about going to an agency. And an agency is defined basically as the government. And so if the process for filing an open records request and complying with an open records request is all dealing with the government, but then the definition says a private party is holding the record, there's an inherent conundrum in there, because what process is that private party supposed to follow? Because the process does not apply to them. And so I think this legislation attempts to remedy that, because the Supreme Court decision basically said, hey, there's not a definition of custodian, and because there's not a definition of custodian, we just have to go to the dictionary. And the dictionary says the custodian is who holds the records. And because the definition of public record says the private party can hold the record, then the custodian ends up being the private party in some of those situations. And so by defining custodian to be the government, you're saying that that records request is going to the custodian, which is going to the government, and that should solve the issue of getting that records request to the right party, and hopefully solving that issue.
Mr. Chairman, if I could add one more thing, if you just, I don't know what you get on artificial intelligence and all the things on y'all's last bill, but I just Googled, said the Supreme Court case, and I came up with an article. The first hit was Parker Poe attorneys, and the headline is Georgia Supreme Court broadens Open Records Act to include private contractors. The first sentence is the Georgia Supreme Court on Monday, this was August 14th, so the day before they made that ruling, issued a ruling that expands the scope of who is responsible for the production of public records under the state's Open Records Act. Well, that's why I say the Supreme Court, we're supposed to make the laws. They rule on those laws. They interpret those laws. And I think what we did was we haven't defined who that records request should go to. And so I don't think they did anything but what they were supposed to. So for me, I'm trying to look at it and said, okay, let's tighten that up a little bit and make sure that all of the training and experts are on these local agencies. They have most of them have a records retention person, a records response person that is going to handle that request. I don't know of any private company that has an open records person.
Chairman Tillery, is that you?
Yeah, Mr. Chairman, I just got a couple of questions. Thank you, Chairman, again. Thank you, Rushi. The first thing I want to clear the air on is there anything in this bill that would prohibit any member of the public from disseminating an open records request once they got it?
Disseminating anywhere?
To anybody. Posting it online, sharing it with their friends,
No.
jumping out of an airplane, throwing it out in the air?
No.
Okay. I'd heard that earlier, and I wanted to make sure. I didn't see that, but I wanted to make sure. The second thing is thank you for clearing that, because I think that's extremely important. But the second thing is we are running – one of the things we've done to run a more efficient government is we've contracted things out. Senator, again, I'm completely with you. I don't want the Napa Auto Parts to be subject to an open records request just because they sold air filters to the Toombs County Road Department. And I think that's what you're after. What I'm worried about is now that we have contracted out so many things in the effort to be more efficient, to lower government expenses over time, have we put ourselves in a position that the custodian is no longer the agency? And how do I handle the response from an agency? I know you've answered open records requests. I've answered open records requests before. I've actually never sent one, but I've answered them. How would I, as a person sending out the open records request, respond if the agency says, I used to be in charge of that, but now let's use prisons. That's probably the easiest one. I could tell you how many people have gang affiliation or illegal in their status, but I can't because they're all at Core Civic. And I'm not trying to single out them or make them bad. What is then the response of the citizen to that answer? Because they don't have that record.
Yeah, so the way the law is supposed to work is that the records request, when it comes to the agency, so let's say it's the city government, when the records request comes to the city, and say the city has offloaded it to a private party, or a private party has the city record, the city is supposed to get in touch with that party and say, you have our city record, we have a contract with you or whatever, we need to get that record back because we've had a records request, and they are supposed to provide that. It might take a little bit longer than the 3 days to respond, but the city is supposed to make active efforts to get that record and get it to the party who's requested it.
I get it if that you may have to ask another follow-up, Mr. Chairman. I get it if that third-party company was retained for the purpose of warehousing records.
Sure.
I'm not chasing that rabbit right now. The rabbit I'm chasing is, hey, you're now performing a government function. We've just contracted it out through public-private partnerships or whatever it is. Why should the DOC know how many surgeries were performed at XYZ private prison last year, or how many people were detained there illegally, or how many people were walked in but didn't walk out?
It kind of goes back to your air filter question. So in my mind, just like we spent public funds on buying air filters, we're spending public funds to put people into prisons, and there's a contract for that. X number of dollars they're paying, for every procedure that's done, for every inmate that's in there, all of those records. And believe me, I want to make dang sure that those records are open, that somebody knows, okay, how much did we pay for an air filter? How many prisoners, because you're paying on a contractual basis. And so that contract is an open record that should be readily available to the Department of Corrections or any agency. That's how you get that information.
Can I ask one more, and I'll leave you alone, Mr. Chairman?
Please.
You won't invite me back to Judy anymore?
No, we won't clap anymore, at least.
I agree with you that should be in the contract, but generally the contract's going to say a per diem rate. It's going to say $28 per person per day. I'm worried that not this current administration, I'm not worried about the folks that are sitting here in these tables right now, but when you realize you can then contract out to potentially get around Title 50-18-70, I'm worried a little bit about that. So I want to help you narrow it down. I don't know how to do that right now. And if you see me against you, it's not that I'm against the idea. I want to protect the Napa Auto Parts. I don't want to create a incentive to contract out for the purpose of potentially not being subject to the Open Records Act.
Would it be better to have something set up where someone has to go to the agency first? Basically, if it's a document or records that is under an agency that's farmed this out somehow, and the request must first go to the agency, and then in the event the agency doesn't have possession or control over it, then you could get to the next layer. Does that make sense?
And you're exactly right. One of the things that is clear in the law is any public agency, said the government entity, is responsible, and any private entity that receives over a third of their funding, is responsible for handling open records requests.
Yeah, but if they say I don't have it,
and this is where, for me, when we look at what's going on with that open records request, there are penalties, including prosecution, for doing that, and we've seen that before, where the remedy is through the superior court system. And there are times when the Attorney General has stepped in to require production of records, and that's some of the penalties that are out there in the open records request, and it's very complicated. It's not an easy issue, and that's where, for me, because your average business is going to go broke when they start getting all of the open records requests. If you want to put them out of business, that's how it's going to happen. Right. That's the whole impetus of the case, is because the law was silent that the request needs to go to public, not to private business.
In my mind, it would solve the issue if you had the request go to the the governmental agency, and then some sort of process set forth where agency says, well, I don't have that, I contracted that out, I don't have access to it. They should, because they have control over it. They at least should have control over it. What if they haven't? What if they didn't keep control over it? And so it's like you might could solve your problem by creating some sort of way, and I know you try to be really simple, but maybe it needs to be more detailed, where there's a way where you still go to the agency first, and then some sort of standard setup where you can get to a private company in the event it's being shown that company's holding governmental records that the government no longer can get. Does that make sense? I mean, that I'm not sure how to draft that right now, but that seems like that would deal with the issue brought up by Chairman Tillery. Chairman Calzert.
Thank you, Mr. Chairman. So, Rusi, I think you hit on the solution. Is it in the law that the agency is required to go to the contractor to obtain documents that are responsive to an open records request?
When you look at the definition of public record, that last clause where it says such documents that have been transferred to a private person or entity by an agency for storage or for future governmental use, that's part of the definition of public record. And so if the city or county or whoever it is has transferred that public record to a private party, then that's for future governmental use. The city has that responsibility when they get an open records request. That's still a public record of the city that they have to go out and get.
It might clarify everything if we just recite that here somewhere that, you know, I love Senator Ginn's idea of let's keep private business out of this, or else why would they ever want to contract with the government if they now have to have their own compliance of records request department? But they should be required, if asked by the person that hired them, the agency that hired them, to give the documentation to do it. If you would say that in here, maybe that you can ask it directly from the private partner, but specify that the public agency is affirmatively required to go get it. That might close that loop up. You and I are on the same.
Yeah, I think that's simpler.
Yeah. Just a thought. You're the dresser and the teacher. Who are you teaching this to? Some university?
No, the city elected officials.
Yeah. That might be a more simple way of doing it, what he said. Make the agency ultimately be responsible. Any other questions for the author? More people want to speak? Or for Mr. Patel? All right, thank you.
If I can, Mr. Chairman, with the, I don't know if you got people speaking for and against, said they, hopefully so. We'd like to listen to them, and then if I can, close out.
I'll always give you that chance to come back up.
Thank you.
Yep. And we have two people speaking against it. Richard Griffiths with the Georgia First Amendment Foundation. And also Sarah, is it? Brewerton Palmer. I could read the first part.
My bad.
That's okay. It's better than mine still.
My long last name.
Oh, you're good. Good afternoon. Well, good evening. We're off to a rough start for Judiciary. 2 bills in. We passed nothing, and it's already over an hour. Y'all go ahead. The floor is yours.
Senators, thank you very much for allowing me to testify. My name is Richard Griffiths. I'm a volunteer board member with the First Amendment Foundation. With me is Sarah Brewerton Palmer, an attorney and the Foundation's president. We at the First Amendment Foundation spend much of our time working for open and transparent government in Georgia, both at the local and state level, providing training to the public, journalists, and public officials about the Open Meetings Act. In fact, we do some with Rusi. Right now, our organization is very concerned about what SB 12 might do. For at least the last 40 years, Georgia law has mandated that when a private entity is paid to perform a service or a function for a government agency, the records it creates about those services are public. This ensures that the public has access to information about government contracts and that agencies can't use private contractors to shield their activities from public view. This has been true and has been consistently applied by Georgia courts and incorporated into statute by the legislature for decades without issue. Senate Bill 12, unfortunately, as written, would blow that up. it would shield government contractors from public scrutiny, cloaking in secrecy the activities of private entities that are paid by taxpayers to do taxpayer work. By making the records of government contractors private and shielding them from Open Records Act enforcement, SB 12 would effectively erect a brick wall between the public and the information about what those contractors and, by extension, the government agencies that hired them are actually doing. Well, this will create a huge loophole in transparency laws and would allow counties and municipalities in the state effectively to contract with private entities for the purpose of shielding government activities from disclosure. I'm not saying that Rusi or his people are going to do that, but someone will attempt to do that, and the way the bill is written, we believe it could be successful. And it could create a huge loophole in transparency laws that might end up regulating industry, for example. It wouldn't be far-fetched to see oversight of portions of industries like poultry farming or transportation of pharmaceuticals disappear behind that brick wall. And you don't have to look back too far to see what the potential financial costs would be and what the real-world problems look like. For example, in 2006, Central Atlanta Progress attempted to lure the NASCAR Hall of Fame to Atlanta, worthy project, but with millions in financial incentives that were kept from the public. Bid documents were shown to government officials and then returned to Central Atlanta Progress, which refused to disclose them in relation to Open Records Act requests. Well, in that case, the state AG had to get involved. He sued for the records, winning in the Court of Appeals, and revealing to the public that taxpayers would have been on the hook for $100 million in incentives, in bonds and direct appropriations. But under SB 12, those financial incentives would have remained secret. Look, Atlanta ultimately lost the NASCAR Hall of Fame to Charlotte. Ironically, Charlotte ran a completely transparent bid process. So this type of transparency is helpful, not hurtful. And I also want to really point out here that existing law already has plenty of safeguards to prevent private contractors from being harassed, right? Only records relating to a company's work for government are public. And even then, there are exemptions in place to make sure that the company's trade secrets stay private. And there are procedural protections built into the Open Records Act to prevent a private company from having to pay for or deal with onerous or expensive record requests. Allowing public scrutiny of the records of private contractors being paid with taxpayer dollars has been the norm in Georgia for decades, and it has served the state well. SB 12 would destroy those decades of bipartisan public policy supporting transparency and make it far easier for agencies to hide malfeasance or the misuse of public funds. And so we ask that you would vote down this bill. Sarah has a few additional comments based on preceding testimony.
Yeah, the Foundation's primary and major concern is the adjustment to the definition of public records to exempt privately created records from a government contractor from that definition, because that means nobody can get them ever. And I think that's very concerning. And that doesn't really go to the question of how do you get that record or what's the pathway for sending the open records request. It just shields those entirely if you make that edit that's in Section 1. And I also wanted to raise a couple of possibly unintended consequences of Section 2 that I've noticed just from my practice doing open records litigation. Under Section 2, let me pull this up. This would strip superior court jurisdiction over specific types of open records enforcement actions, which currently you can bring against an agency or you can bring against an individual records custodian within that agency. You can also bring under 50/1874, which contains the private enforcement mechanisms. That gives the Attorney General the authority to enforce the act, but it also gives private citizens the ability to bring civil fines claims against folks who are negligently or willfully violating the act. And that's an important mechanism just because the Attorney General doesn't have enough time to go chase every single Open Records Act violation in the state. But under binding Supreme Court precedent, under the identical language in the Open Meetings Act, those civil fines claims can only be brought against individual actors, not against agencies. And so if you, in the jurisdiction stripping provision in Section 2, I have a lot of concern that it would shut down the ability to bring a claim against an individual, because this would only allow jurisdiction for claims against agencies. And I think that might an unintended consequence of that would be to effectively repeal the civil fines that exist in 50/1874. It's also a really important enforcement mechanism just because the current Attorney General has determined there's a conflict of interest for his office enforcing the Open Records Act against state level employees. So those civil fines are really the only existing mechanism to incentivize compliance by individual officers. So I think that some of the suggestions that y'all were talking about earlier are better ways where we're focusing on pathways of where does that request go, not trying to change the jurisdiction of where does that enforcement action, what does that look like, or changing the definition of a public record.
That's a good segue to me. The intent appears to be to prevent people from just going after private business and trying to get documents there they could get through the government. I think that's what's been stated as the intent. I don't think the intent's ever to have documents flow to these private companies that now someone can't get. And we're worried about the unintended consequence of that happening, obviously, or someone in the future trying to do that. If we did something that was suggested by some of us where we at least make certain the agencies responsible and hold them accountable, is that something that your group could support? If we had language like that, would you be okay with the bill then?
Yeah, I think we would need to make sure, a very common response that I have seen from agencies in response to requests that might involve, records from a contractor is, I asked them for it and they didn't give it to me, and that's all I can do. So I think it would make sense to channel those requests to the government. They have much more expertise in dealing with these. The private companies don't. It's going to generally be a much smoother process, but there has to be some way to make sure that if the agency can't, asked and couldn't get them, what do we do next? Whether that's an obligation for the agency to go get them, that then a private person could sue the agency if they didn't, actually make any actual efforts, or whether it is, a private action to just, and for an injunction to get the records from that private company.
Can't be a dead end.
Yeah, exactly.
Which is what this is looking like at the moment.
It'd be helpful, at least from my standpoint, and the author may or may not agree, but I think some suggested language from your group would be helpful so we could see something that you say, okay, this solves the harm that we're worried about with this bill. Because I don't think the status quo works, and for my take, I do think we need to clarify this.
We'd be more than happy to have you work.
I'm gonna let you close out. Don't worry. Let's let them finish first. You'll have anything else you want to add?
No.
Any questions from the committee? We do have a question, Senator Kennedy.
Thank you, Mr. Chairman. You mentioned in your comments that there was a provision, or you interpreted a provision that divested the Superior Court of oversight.
Yeah.
Does it terminate the oversight, or does it move that oversight to some other location?
So it's the jurisdictional provision, which is sort of the waiver of sovereign immunity, the thing that lets the court act. And currently, that allows suits. If you read the strike-through language at line 31, the existing law allows suits against persons or agencies having custody of records, and that allows you to you can sue the Department of Health if you want some database, or you can sue if there's a particular officer that is acting wrongfully. For example, if you guys remember the first criminal prosecution under the Open Records Act a few years ago against an aide of Mayor Reed's that was shielding some water department records, you could sue that person for fines for violations of the Open Records Act. This revision, custodians of records or their agency, and then in Section 1, a custodian is defined solely as an agency or a designated open records officer, although an agency doesn't have to do that. So I think it really just limits the Superior Court jurisdiction to suits against an agency, and that's it.
Okay. Thank you, Mr. Chairman.
Any other questions from the committee? All right, thank you. Come on up, Senator, again. Give you the last word, and if you want to come back up as well, Mr. Patel, it's up to you.
Thank you, Mr. Chairman. And thanks for this presentation from the First Amendment Foundation. I get kind of some angst in there. And one of the things I always try to make sure is, before I submit a bill, I try to make sure I reach out to my media folks, press folks, those kind of folks. I want to give a shout out to my friend Mike Buffington, who runs a bunch of local newspapers in my area. But for me, I do want to offer perhaps a suggestion that I'd ask the First Amendment Foundation if this might work. On lines 22 and 23, where we have right now stricken by a private person or entity in the performance of a service or function for or on behalf of an agency, or when to Chairman Tillery's point, I think if we unstrike that portion right there, I think that addresses your concern, and I think that addresses the First Amendment Foundation concern, is that anybody that's performing a function for a government entity, that it's clear that it's an open record, and that it's a public record. And
what would your bill accomplish if we did that, though?
The records request only goes to the public entity, goes to the government agency where we're spending tax money.
So you would write something separate in that says that?
Well, that's it does say that. Because when we added into lines 18 and 19, the custodian is the agency, and the definition of agency is the government entity that it's not a private corporation. And I'll let Mr. Patel, he's much better explaining it than I am.
Yeah, so that definition of custodian, when you go back and look at that Middle Iron case from August, it has this analysis of what is a custodian. And because there was no definition for custodian in the Open Records Act, they end up saying that in the view of these definitions, they look at the dictionary basically. They look at the dictionary and they say, in the view of these definitions in the dictionary, the term custodian found in the Open Records Act is expansive enough to include anyone with the requisite care and control of the public records. And so in this case, because there was no definition of custodian, the person in control in that situation was a private party. And so they're saying they're subject to the Open Records Act. But by defining custodian as the government here, it gets rid of that issue that came up in the Mill Iron case, is that they're saying, by defining it, you're saying basically the custodian is the government, and so that records request needs to go to the government.
And I think if we do that, I'm making sure the First Amendment Foundation argument is covered. I think that we're making sure that the records request goes to the government entity, because that's why it is an open record. It's not, we're trying to get in anything that's out there. And so if a private person has it, a private entity has it, that it's still a public record, and it's still covers what we need to do.
Senator Parent.
Thank you so much, Senator. I was just wondering what the enforcement mechanism would be then, if enforcement for the taxpayers, if the entity won't hand over the records.
It's the exact same enforcement as it is right now. You go through Superior Court, and there's a lot of good many penalties, I think, for somebody that's trying to hide the records.
But here you would, I think, only be able to go after the Superior Courts would only have jurisdiction over the custodians.
That's correct.
Because it would take out the persons, meaning that there wouldn't be direct, right? Am I right?
All my friends that work in government agencies, they don't want to go to jail. And that's where, for me, I can promise you, they'll get those records.
So you're saying when you can sue the agency, they will then go get it from the...
That's correct. If that record's out there, and you're going to something that and this spells it out, by an agency or by a private person or entity in the performance of a service or function for or on behalf of the agency, then that makes it a public record. And
I'm sorry. Finish.
And to me, I don't know anybody that wants to go to jail.
No, and nor do I. My only, I am wondering a little bit though, because in the definition of custodian, it says charge, but custody and control. You could say, I don't have custody or control over these public records because I don't have them. So I would think we might need to edit that a little bit to get at what you're trying to accomplish with removing the strikeout, I believe.
And
I see what you're saying, but I think the definition of custodian saying that they have charge of those records is that those are public records, and the custodian is the one responsible for, even if it's with a private party, they're in charge of those records.
Well, it may be splitting hairs, but it is an and. You've got an and, not an or, so.
Yeah.
Senator Rhett.
Is it easier to go after the custodian or go after the entity, the private entity, to get those records?
What I'm trying to do with the bill is to make sure that the records request goes to the public entity. They get training from different agencies and different folks on how to handle those. They know how to do it, and that's where, for me, anything, I want to make sure the information's out there for you. And I want to make sure that that request is handled timely, properly, and that's where I don't know of any private companies out there that are training on open records requests. And that was why I think the Supreme Court made the right ruling. I think they left it to the legislature to clarify that and clean it up. And so that's what the bill's offered, is to just clarify that gap in there, that open records requests should go to public entities.
I guess the question is, whether or not the records can't be hidden so anybody can go look at it. That's the main question, seems like, here.
Yes, sir.
Senator Hatchett, you want to close this out?
Sure. Thank you, Mr. Chairman. I think I understand what Chairman Frank or Senator Ginn is trying to do here. But the way this bill is drafted essentially is, from my reading, is you are channeling all the requests to the agencies. But what you did was you cut out the definition of what a public record is, so that if an agency hires a private company and the private company creates the document wasn't transferred, but if they create the document, then that document's not searchable, or it can't be subject to open records. Is it your intent to so those documents can't be subject to open records, or is it just your intent to have all open records requests go to agencies, and then the agencies can still go get those documents because those are public records?
If the agency's requested to get the record, and it's by a private person or entity, in the performance of their duty. So you contracted with, whether it's a Department of Corrections or the guy that's supplying air filters for the Napa Auto Parts store, said
I think that's why Senator Ginn is talking about just leaving the definition of public record alone and not striking that language.
Okay.
Is just leaving that alone.
It's still a public record, so, and I'm just channeling where it's going, that request is going.
Do you have last word? And
I just wanted you to know I prefer to go to AutoZone.
I figure that's, well, I was reluctant to call upon you. Not because of AutoZone, but I think, Senator, let's hold the bill and get it right in committee so you won't have this file on the floor of the Senate. And so if you want to work with the First Amendment folks or anybody else you want to work with and come up with some language, it seems like we're all saying the same thing as our goal, but and you may have just come up to with a solution. I don't know, but let's get it right. So I'll let you work on that and get us a substitute when you have it ready.
Yes, sir.
All right.
Thank you, Mr. Chairman.
All right. Thank you.
And I hope I paid enough to I'm not the lawyer.
Well, now you got to add another $1. With that, we are adjourned. Thank you.